In a significant legal triumph, Intel has emerged victorious in a long-standing antitrust case against the European Union. The European Court of Justice recently dismissed the European Commission's appeal to reinstate a hefty €1.06 billion fine imposed on Intel in 2009. This decision marks the end of a nearly two-decade legal battle between the tech giant and EU regulators. Intel's victory is not just a win for the company, but also a landmark moment in the history of European competition law. The case revolved around Intel's rebate practices with major computer manufacturers like Dell and HP. The European Commission had initially found these practices to be anti-competitive. However, the General Court later overturned this decision, citing insufficient evidence. The European Court of Justice's ruling upheld the General Court's decision, signaling a major shift in how antitrust laws might be interpreted moving forward. At the heart of the Intel antitrust case were serious allegations about the company's rebate programs. These programs offered significant financial incentives to computer manufacturers like Dell, HP, NEC, and Lenovo. The European Commission argued that these rebates were designed to edge out Intel's main competitor, Advanced Micro Devices, or AMD. They claimed that Intel's rebate practices violated EU antitrust rules by abusing its dominant market position. This practice was seen as a way for Intel to maintain its dominance in the CPU market unfairly. According to the Commission, these anti-competitive practices harmed consumers by limiting their choices and potentially slowing down innovation in the CPU market. By making it difficult for AMD and other competitors to gain a foothold, Intel's actions were said to reduce the competitive pressure that drives technological advancements and price reductions. In 2009, the European Commission handed down a record-breaking €1.06 billion fine to Intel. This decision was based on their assessment that Intel's rebate practices were anti-competitive and detrimental to the market. The fine was one of the largest ever imposed by the European Commission at the time, reflecting the seriousness with which they viewed Intel's actions. Intel, however, was not willing to accept this ruling without a fight. The company launched a vigorous legal challenge against the Commission's decision, arguing that their rebate programs were standard industry practice. They contended that these practices did not prevent competitors from gaining market share or offering competitive products. Intel's response marked the beginning of a protracted legal battle that would see the case go through various levels of judicial review. The company's argument centered on the claim that the Commission's analysis was flawed and did not adequately demonstrate actual harm to competition or consumers. In the face of the substantial fine and the serious allegations, Intel launched a robust defense. The company argued that their rebate programs were not anti-competitive, but rather a common practice within the industry. They contended that these rebates were designed to incentivize loyalty among their customers and were beneficial for both manufacturers and consumers. Intel maintained that their practices had a pro-competitive effect by driving down prices and fostering innovation. They argued that the European Commission's assessment lacked a proper understanding of the CPU market's complexities. According to Intel, the Commission had failed to demonstrate that their rebate programs had caused actual harm to competition or consumers. Intel's legal counter was not just about defending their practices, but also about challenging the European Commission's approach to antitrust enforcement. This legal battle would eventually lead to a significant turning point in the case. In 2022, a significant development occurred when the General Court of the European Union overturned the European Commission's 2009 decision. The court annulled the €1.06 billion fine imposed on Intel, marking a crucial victory for the company. The General Court found that the Commission's analysis of Intel's conduct was incomplete and did not sufficiently prove that the company's rebates had a negative impact on competition. The General Court emphasized the need for a thorough assessment of all relevant circumstances, including the actual effects of the rebates on the market. They highlighted that the Commission's decision relied too heavily on the potential anti-competitive nature of the rebates without adequately demonstrating their real-world impact. This ruling underscored the importance of robust evidence and rigorous analysis in antitrust cases, especially in complex industries like technology. The General Court's decision was seen as a major setback for the European Commission, which had pursued this case for over a decade. This ruling raised questions about the Commission's ability to effectively regulate dominant tech companies. Despite the setback at the General Court, the European Commission remained determined to uphold its original decision. They filed an appeal against the General Court's ruling, seeking to reinstate the €1.06 billion fine. The Commission argued that the General Court had erred in its interpretation of the law and had not given due weight to the evidence presented. In its appeal, the Commission aimed to address the concerns raised by the General Court and clarify its position. They maintained that Intel's rebate practices were indeed anti-competitive and had a detrimental effect on the market, ultimately harming consumers. The Commission argued that the General Court had set an unduly high bar for proving anti-competitive behavior, and that their initial analysis was sound. This appeal underscored the Commission's commitment to enforcing competition law and regulating the behavior of dominant companies, particularly in the technology sector. The appeal set the stage for a final showdown at the European Court of Justice. In a decisive ruling, the European Court of Justice dismissed the European Commission's appeal, effectively confirming the General Court's 2022 decision to overturn the €1.06 billion fine imposed on Intel. This verdict marked a resounding victory for Intel, bringing an end to a protracted legal battle that had spanned over a decade. The ECJ's decision reaffirmed the General Court's findings, stating that the Commission's analysis of Intel's conduct was insufficient to establish a breach of EU antitrust rules. The ECJ emphasized the need for a comprehensive assessment of all relevant factors, including the actual impact of Intel's rebates on the market, rather than relying solely on their potential to harm competition. This ruling underscored the importance of robust evidence and a thorough analysis in antitrust cases, particularly in complex and dynamic industries like technology. The ECJ's decision has significant implications for both Intel and the broader tech industry. For Intel, it represents a vindication of their business practices and a removal of a significant financial burden. The ECJ's decision to uphold the General Court's ruling has far-reaching implications for Intel. For one, it removes a significant legal and financial cloud that has hung over the company for over a decade. The annulment of the €1.06 billion fine provides Intel with a substantial financial reprieve, allowing the company to allocate resources to other strategic areas, such as research and development. This ruling also serves as a vindication of Intel's business practices, reaffirming their approach to competitive strategies. It provides the company with a degree of certainty and confidence in their operations moving forward. Intel can now pursue its business objectives without the looming threat of a massive financial penalty. Moreover, the decision could embolden Intel and other dominant tech companies to implement more aggressive competitive strategies. The ECJ's ruling in the Intel case has significant implications for the broader tech industry. For one, it provides greater clarity on the application of EU competition law, particularly concerning rebate programs and market dominance. Tech companies operating within the EU now have a better understanding of the legal framework and the standards they must meet to avoid antitrust violations. The ruling also signals a potential shift in the balance of power between regulators and tech companies. While the European Commission remains a formidable force in enforcing competition law, the decision highlights the challenges they face in proving anti-competitive behavior in complex and rapidly evolving markets. This could lead to a more cautious approach from regulators and might encourage them to gather more robust evidence before imposing fines. For the tech industry, the decision could encourage more aggressive competitive strategies, as companies seek to leverage rebate programs and other incentives to gain market share. However, they must remain mindful of the need to demonstrate that such practices do not harm competition or consumers. The conclusion of Intel's antitrust case marks the end of a significant chapter in European competition law. This case, spanning nearly 2 decades, has shaped the legal landscape for tech companies operating within the EU and has set important precedents for future antitrust enforcement. The ECJ's final ruling provides valuable clarity on the application of competition rules, particularly concerning rebate programs and the assessment of market dominance. This case underscores the increasing scrutiny faced by tech giants and the EU's commitment to ensuring fair competition within its digital markets. The European Commission, despite its defeat in this instance, remains a powerful force in regulating the tech industry, and companies must be mindful of their obligations under EU law. The Intel case serves as a stark reminder that even the largest corporations are not above the law, and that anti-competitive practices will be met with robust enforcement. As the tech industry continues to evolve and new challenges emerge, the lessons learned from this landmark case will undoubtedly shape the future of competition law in the digital age.